Hello, everyone. Welcome back to our channel, Us Immigration News. We hope you're doing great. Well, in today's video, we will be talking about USCIS big breaking announcement. So, to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for upcoming episodes. So, without any further delay, let's jump into the video. The United States Citizenship and Immigration Services, USCIS, has announced a new parole program aimed at promoting family unity among American citizens and their immediate family members. This program, designed to offer relief to spouses and stepchildren of American citizens, allows eligible individuals to remain in the U.S. while adjusting their immigration status. This video delves into the details of the parole program, its eligibility criteria, application process, and important dates. Background and purpose. The parole program aligns with the Biden-Harris administration's commitment to keeping families together. It provides a legal pathway for spouses and stepchildren of American citizens to stay in the U.S. without having to leave for consular processing. This initiative is particularly beneficial for those who have been residing in the U.S. for an extended period and are currently in a legal limbo. Program announcement. On June 18, the Department of Homeland Security, DEEDS, announced new actions to support family unity in the immigration process. This announcement was a significant step in fulfilling the administration's promise to maintain family cohesion within the immigration framework. The DAs is setting up a case-by-case process for parole in place, applications for certain spouses and stepchildren of American citizens who have been in the U.S. for at least a decade. Key dates and implementation. USCIS has specified that the new parole program will start accepting applications on August 19, 2024. It is crucial to note that any application submitted before this date will be rejected. Detailed guidelines and eligibility criteria will be published in the Federal Register, which will serve as the official documentation for the program. Eligibility criteria. Continuous presence. To be eligible for the parole program, applicants must have been continuously present in the U.S. for at least 10 years. As of June 17, 2024, this means they must have been residing in the U.S. since June 17, 2014, without any significant interruptions. Valid marriage to an American citizen. Applicants must have a valid marriage to an American citizen as of June 17, 2024. This requirement is strict, and marriages that occurred after this date will not be considered for the program. Admission and parole status. Applicants who were admitted to the U.S. with a visa or granted parole at the border are not eligible for this program. The program specifically targets those who entered the U.S. without admission or parole. Criminal record and public safety. Applicants must not have a disqualifying criminal record or pose a threat to national security or public safety. This includes not being involved in terrorism or gang activities. USCIS will conduct thorough background checks to ensure applicants meet these criteria. Favorable exercise of discretion. USCIS will also consider whether applicants deserve a favorable exercise of discretion. This involves assessing the applicant's overall conduct and respect for U.S. laws. For example, a history of multiple minor offenses, such as repeated traffic violations, might negatively impact the application. Inclusion of stepchildren. The parole program extends to certain non-citizen stepchildren of American citizens. To qualify, these children must have been physically present in the U.S. without admission or parole as of June 17, 2024. Have a qualifying stepchild relationship with the American citizen, meaning the marriage between the stepchild's parent and the American citizen occurred before the child turned 18. Be under 21 years old at the time of application. Application process. The application process for the parole program will be detailed in the Federal Register notice. It will include information on eligibility factors, application procedures, and associated fees. Applicants must wait until the Federal Register notice is published and the specified start date, August 19, 2024, before submitting their applications. Federal Register noticed. The Federal Register will serve as the official source of information for the parole program. It will provide comprehensive details on eligibility, application steps, and important dates. Applicants are advised to stay informed by regularly checking the Federal Register and USCIS website for updates. Practical considerations. Applicants are encouraged to consult with immigration attorneys to understand their eligibility and prepare their applications. Legal advice is crucial, especially for those with complex cases, such as uncertain admission statuses or minor criminal records. 1. Valid legal marriage to an American citizen. To demonstrate eligibility for parole based on marriage to an American citizen on or before June 17, 2024, you must gather specific evidence. Marriage certificate. Obtain and prepare a copy of your valid legal marriage certificate. Proof of identity. Collect documentation proving your identity, such as a state or country driver's license, an identification card, or a birth certificate with a photo ID. 2. Proof of your spouse's citizenship. Gather evidence of your spouse's U.S. citizenship to strengthen your parole application. Acceptable documents include passport or a copy of the passport, birth certificate, naturalization certificate. 3. Continuous presence in the U.S. Establishing your continuous presence in the U.S. for up to 10 years as of June 10, 2024 is essential. Collect the following types of evidence: rent receipts and utility bills, documenting your living arrangements and utility usage over the years, school records, your personal school records, including letters, grades, etc. Note, documents from your children are not acceptable unless they directly reference your presence. Hospital and medical records. Records from medical visits or hospital stays that confirm your presence. Attestations from organizations. Confirmation of your residence by religious entities, unions, syndicates, or other organizations. Official records. Records from religious ceremonies, money order receipts, and other transactions within the U.S. Children's birth certificates. For children born in the U.S. Bank statements and financial documents. Bank statements. Car registrations, licenses, titles, and real estate documents. Tax returns. Your tax returns or receipts as further proof of your physical presence. 4. Special considerations for stepchildren. If applying for parole as a stepchild, evidence of the relationship with the American citizen spouse and proof of presence in the U.S. on June 17, 2024 are required. Unlike adults, stepchildren do not need to prove a 10-year presence. 5. Avoiding fraud and seeking legitimate legal assistance. When preparing your application, it is critical to avoid scams and only seek advice from qualified individuals. Legitimate legal representation. Only lawyers licensed to practice in the U.S. or accredited representatives from recognized organizations can provide legal advice. Notary publics are not authorized to offer immigration services. Warning signs. Be cautious of individuals guaranteeing results, using predatory cost structures, asking you to sign blank papers, or refusing to let you review documents. Documentation. Keep copies of all documents filed on your behalf and ensure that all agreements with your lawyer are in writing and signed by both parties. 6. Reporting scams and protecting yourself. The USCIS emphasizes the importance of reporting any suspicious activities or scams. Forms for immigration applications are free and can be downloaded from the USCIS website. Always ensure you are dealing with official channels and keep up to date with the latest information from reliable sources. 7. Future announcements and disqualifying factors. While current guidelines outline what documents to gather, disqualifying factors for parole eligibility are yet to be fully detailed. It is anticipated that serious felonies, such as drug possession, domestic violence, serious crimes, and significant offenses like DUI, will likely disqualify applicants. Recent developments in U.S. immigration policies and procedures. The landscape of U.S. immigration policies is continually evolving, influenced by legislative actions, administrative updates, and shifting public sentiments. This video explores the significant developments in U.S. immigration, focusing on the implications for deferred action for childhood arrivals, DACA, recipients' recent changes in non-immigrant visa policies, and broader immigration trends. Deferred action for childhood arrivals, DACA. Background and current status. DACA, established in 2012, provides temporary protection from deportation and work authorization to eligible undocumented immigrants who came to the U.S. as children. While it does not offer a path to permanent residency or citizenship, it has been a crucial lifeline for hundreds of thousands of young immigrants. Recent developments. No immediate changes for DACA recipients. As of now, there have been no drastic changes affecting DACA recipients directly. They continue to hold their status, allowing them to live and work in the U.S. without fear of deportation. Potential pathways to residency. The administration has shown interest in creating pathways for DACA recipients to transition from temporary work visas to permanent residency. This would involve granting temporary work visas initially, followed by access to special waivers for permanent residency through family petitions or national interest considerations. Implications for DACA recipients. Temporary work visas. DACA recipients might receive temporary work visas, providing them more stability and work opportunities. National interest waivers. These could allow DACA recipients to apply for permanent residency, particularly if they can demonstrate their work benefits the U.S. on a national level. Non-immigrant visa policies. Recent policy changes. Discretion and waiver considerations. Recent updates to the Foreign Affairs Manual instruct consular officials to exercise discretion in considering waivers for non-immigrant visas, such as temporary work or student visas. Applicants can now question decisions not to recommend waivers, potentially increasing their chances of approval. Impact on adjustment of status. Individuals adjusting their status to permanent residency will need to gather substantial evidence to prove eligibility for immigration benefits. It is their responsibility, not the immigration department's, to provide necessary documentation. The SAVE Act. Purpose. The SAVE Act, recently passed by the House of Representatives, aims to ensure voter eligibility by requiring proof of U.S. citizenship for federal election registration. Controversy. Supporters argue it prevents voter fraud by non-citizens, while opponents claim it unnecessarily burdens eligible voters without specific identification forms. Political impact. Passed with a vote of 198. It reflects deep political divides, especially in an election year, and awaits further deliberation in the Senate. Public sentiment on immigration. Gallup poll insights. A recent Gallup poll shows that 55% of Americans favor reducing immigration levels, the highest percentage since 2005. This shift reflects concerns over economic, social, and cultural impacts, influencing legislative priorities and political strategies. Visa Bulletin updates. Importance for applicants. The U.S. Department of State's monthly Visa Bulletin provides crucial updates on visa availability and priority dates, guiding prospective immigrants and visa applicants. Recent changes. Notable advancements in priority, dates for specific visa categories, offer new opportunities for applicants to navigate the immigration process more effectively. Practical advice for applicants. Navigating new policies. Stay informed. Constantly monitor updates from the U.S. Citizenship and Immigration Services, USCIS, and the Department of State to stay abreast of policy changes. Consult legal experts. Seek advice from immigration attorneys to understand how new policies and legislative actions might affect your case. Document preparation. Ensure you have all necessary documentation and evidence to support your immigration applications, especially in light of increased scrutiny and new discretionary powers granted to consular officials. Handling adjustment of status. Gathering evidence. Collect and organize all required documentation to prove your eligibility for immigration benefits. Even if you have previously submitted documents, you may need to resubmit them. Provisional pardons vs. Parole. Evaluate whether to continue with provisional pardons or apply for parole. Consider factors such as the timeline, current status, and any minor legal issues that could impact your application. Future outlook. Continued evolution of policies. U.S. immigration policies will likely continue to evolve, influenced by political dynamics, public sentiment, and judicial rulings. Keeping informed and prepared will be crucial for navigating these changes successfully. Potential legislative changes. Comprehensive immigration reform. There may be future legislative efforts aimed at comprehensive immigration reform, potentially addressing issues like DACA, visa quotas, and pathways to citizenship. Public opinion influence. Shifts in public opinion, as reflected in polls, will continue to shape the political landscape and legislative priorities, impacting immigration policies. Impact on immigrants and applicants. Increased opportunities. Changes in visa policies and potential pathways to residency could create more opportunities for immigrants to achieve stability and legal status in the U.S. Challenges and uncertainties. Navigating the complex and often changing immigration system will remain challenging, requiring vigilance, legal support, and thorough preparation. The current and forthcoming developments in U.S. immigration policies present both opportunities and challenges for immigrants and prospective visa applicants. Understanding the intricacies of these policies, staying updated on legislative actions, and preparing meticulously can help individuals navigate the system more effectively. The evolving nature of immigration law underscores the need for continuous adaptation and informed decision-making to achieve desired immigration outcomes. Engage and stay informed. Community support. Join immigrant support groups and forums to share experiences and gather information. Feedback and advocacy. Participate in advocacy efforts to influence positive changes in immigration policies and provide feedback to policymakers. The dynamic interplay of legislative decisions, public opinion, and administrative procedures will continue to shape the future of U.S. immigration. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you're doing great. Well, in today's video, we will be talking about USCIS announces parole program for spouses and stepchildren of American citizens. The United States Citizenship and Immigration Services USCIS has introduced a new parole program aimed at uniting American citizens with their immediate family members, particularly spouses and stepchildren. This program allows eligible individuals to remain in the US while adjusting their immigration status, providing a legal pathway without the need for consular processing abroad. Background and purpose. The program supports the Biden-Harris administration goal of keeping families together, especially benefiting those who have lived in the US for a long time and are in the legal limbo. Program announcement. On June 18, the Department of Homeland Security (DHS) announced actions to support family unity, fulfilling a key promise of the administration. The program will consider parole in place applications on a case-by-case basis for certain spouses and stepchildren of American citizens who have been in the US for at least a decade. Key dates and implementation. Applications will be accepted starting August 19, 2024. Detailed guidelines and eligibility criteria will be published in the Federal Register. Continuous presence. Applicants must have been continuously present in the US for at least 10 years as of June 17, 2024. Valid marriage to an American citizen. Applicants must be married to an American citizen as of June 17, 2024. Admission and parole status. Those admitted with a visa or granted parole at the border are not eligible. Criminal record and public safety. Applicants must not have disqualifying criminal records or pose threats to national security. Inclusion of stepchildren. Eligible stepchildren must have been present in the US without admission or parole as of June 17, 2024, have a qualifying stepchild relationship and be under 21 years old at the time of application. Application process. The application process and further details will be outlined in the Federal Register. Applicants are advised to wait for official notice and consult with immigration attorneys for guidance. Avoiding fraud. Applicants should seek advice only from qualified legal professionals and be wary of scams. While guidelines on disqualifying factors are pending, serious felonies are expected to disqualify applicants. This parole program represents a significant step towards maintaining a family unity within the US immigration framework.